Welcome back to Insight. We've got Trisha here from Barrett McNagny Law Firm, and this is a great topic because estate planning, people think I need to have an estate. and
not true.
Yeah.
And I get that a lot. I don't have any money. All I have is debt. I don't need to have a will. And that just isn't true, especially if you have young minor children. Because that is the one place that you can name who the guardian is, who has physical custody of your children if, God forbid, something would happen to you while they were minors.
And I'm guessing that the hearsay doesn't always work. Just because you may have said something to some person.
No, that doesn't come into play.
Yeah.
Everybody that is has an interest in that child, it would have the opportunity to come forward and say why they thought they were best. And that could be, probably shouldn't say this, but that could be the mother-in-law who you don't want to have custody of the children. So, not my mother-in-law, of course. She's wonderful. But so yes, you need to put in your documents who it is that you want raising your children and who you think would raise them with the same values that you have.
I assume that people pass without a will rather often. What happens in those cases? I mean, obviously we just talked about the kids, but then the debt and things like that. Right. Where does all those things go? It seems like a terrible burden.
Yeah, it really is. First of all, it still has to be administered. Assets are frozen at time of death, and so the court has to appoint someone to serve as the personal representative of your estate. If you don't have a will, you don't designate who that person is. So it may be somebody that isn't very familiar with your affairs. But then, if you don't have a will, your assets, after all the debts are paid, your assets pass by state law, the intestacy statute. And it governs depending on whether you're married, not married, first marriage, second marriage, children, parents alive, but it governs where your assets pass. And it's very strict, and there's no leeway. It will pass as governed by that Indiana law.
Does someone who wanted to start this process actually sit down and meet with you, or is it even is it even that much? I mean, I don't know how hard this process is.
Yeah, the process is we send out a questionnaire. When somebody contacts us, we send out a questionnaire. They fill out the questionnaire. It has information about their family and then their financial affairs, life insurance, retirement accounts, etc. We have a first meeting. That first meeting usually takes about an hour. Then I go back and draft documents based off of what I find their objectives are and what we've talked through in that meeting. And then we have a second meeting to have them come in, review the documents, make sure everything's like they want it, and then we sign the documents. And
sometimes, and maybe I'm wrong, you can also anticipate some things that might mean that I can pass along more to my heirs as well, right?
Yes, absolutely. Well, first of all, we do a lot of tax work, a lot of tax planning. The good news is in 2013, Indiana did away with the state death tax, so we don't have to worry about the inheritance tax anymore. But individuals that have sizable estates, and right now the exemption is $5,450,000 from the federal estate tax. If they're over that $5,450,000 limit, there's some planning that we can do to make sure that we can pass as many assets as possible to the children tax-free. We also look at a lot of charitable giving, and that is a way to reduce tax liability, but it's also a way for people to remember their favorite charities and teach their children and their families how to give as well.
What an opportunity, though, to bless people one last time and take away all the hassle, I guess. You don't want to leave people and their last memory is, oh my gosh, this is so much work now.
This was a mess, yeah, right. Yeah. And there are other documents besides just the will. It's very important that people think about powers of attorney, appointment of healthcare representatives, and living wills. Those are documents that deal with, you're still living, but for some reason you can't take care of your own affairs. Who do you want taking care of your finances? Who do you want the physicians consulting with regarding health care?
If you'd like to find out more, contact the experts at Barrett McNagny. You see the phone number there and the website. We'll be right back on Insight.